going live. You're live, sir.
Okay, thank you. I'd like to welcome everyone to the meeting tonight of the Conservation Committee. The first order of business is to call to order, and second is, Council, can you take attendance?
Sure. Reinhardt? Mr. Epicor? Mr. Camiso?
Here.
Mr. Fine?
Here.
Ms. Lockhart?
Here.
Mr. Miller?
Here.
Ms. Plotsky?
Here.
Mr. Simpson?
He's on the screen.
Is it?
Right here. Sorry, is Mr. Simpson here? Am I not seeing him? Yes, there he is.
He's there.
Mr. Tunney
Here.
and Mr. Epicoro.
Yeah.
All right.
All right. Welcome, everyone. I think that the first order of business then would be to approve the minutes of the last meeting. Do I have a motion?
Make a motion. Motion.
Do I have a second?
Second.
Second.
All right. Counselor, did you get that?
Yes.
Who and who?
I think it was
All right.
Mr. Camiso and Mr. Tunney.
All right.
Fine.
Okay, all in favor?
Aye.
Aye.
All opposed? All right. So the first order of business is going to be local law B. I know that no one has any comments to make on that. But does anyone want to start off with a comment there?
Mr. Chairman,
Yes,
Mr. Chairman,
yes.
okay. I just received from the clerk a 30-page paper letter from Mr. George McHugh, who I believe is a supervisor out in Queens, and attaching some court document about this law and about another law that was challenged in court. I'm kind of concerned about the legality of this in terms of it. I'm not a legal, I'm not a lawyer. I haven't had time to read the whole thing, but apparently there's been some court decision in Maryland that, if not the exact same, a similar law has been shut down because of it being preempted by state law. And so that's one of my concerns, and it was part of it. What they're talking about also is that this is not enforceable by local or even county. Again, I don't know if that's true. I'm kind of wondering why it would be, why we wouldn't be urging the EPA and the DEC to be, if the emissions are not good, that to raise the standards or whatever, so that they do comply to the right thing. So one of my thoughts was, I don't know what the rest of the committee thinks about asking the county attorney to take a look at this. I'm assuming everybody else got it. Just came like 4 o'clock in my email. That maybe we should take a look at this and ask the county attorney what she thinks about this and do some research on it.
Well,
If I may, Mr. Reinhardt, or
Yeah.
if you want to
yeah,
respond?
go ahead, Vicky.
I think what I did see the letter and read most of it. I think what he's referring to might have had more pertinence for a prior version of the law. I think the current amendment in the law, which exempts facilities that have both been burning the waste that's listed in the law and have been doing so pursuant to a lawful permit, this law would have no impact on those facilities. So that has alleviated any of the constitutional arguments about takings and things that have been discussed very extensively over the past several months. So I think the language of this new law is very sustainable and presents a very different picture than might be considered in those cases that Mr. McHugh is referring to. So I do support the law, and it might be a little early on, but I would like to put a motion out there to pass this with a favorable recommendation I'm sure people might want to keep discussing it, but I do want to put a motion out there for that.
I'll second it.
Thank you, Vicky. And
Before we go further with that, could I just ask my colleague, is there any harm in having the county attorney look at that in light of this court law, or has that been looked at?
Yeah.
Well, I would answer
Yes.
that, in general, as Vicky alluded to, the issues of the Coiman's law and the legal issues around that and that version that Rick Touche had put up like a year ago or last session. I think those issues have been looked at quite extensively. And I guess one point I want to make before I think I might have seen, Rebecca, did you put your hand up? Was that, oh, okay. Well, I thought someone else did. Anyway, what I do want to say is that this law is really much broader than whatever Lafarge wants to do. This is a law that's addressing all kinds of new facilities. The law, the town law in Coiman's was more focused on the Lafarge operation. This law is not. It's focused on new waste burning facilities very broadly. And I think that's why there are a lot of differences in the version that is before us now. You know, I just want to make that point that this is not a law that's simply a county version of the town of Coiman's law. It's
Mr. Chairman, can I ask you, and excuse if I don't know, if I should know this. This law apply both to public and private?
public and private what?
Entities that might be burning or, you know, doing this kind of work?
Well, it does. The exemptions that are in it do address a lot of that. You know,
Yeah, I saw some,
scope of facilities that are addressed.
I saw that. It seemed to me that it did exclude a lot of public entities.
It does exclude certain ones that are spelled out in sections. I
Right.
think
Okay.
section 4. Yeah.
Mr.
Paul?
Mr.
Well,
Chairman,
Mr. Chairman, point over as a committee member, could I have the floor, please, before Mr. Bergdorf is not on the committee?
certainly.
Thank
All
you,
right,
sir.
all right, go ahead, Matt. Sorry. I
I
didn't-
appreciate that. That's okay. Appreciate it. Thank you, Paul. I just want to reiterate again, I know you both have said it, but I've had conversations with Mr. McHugh in the past on this, and he still is operating, unfortunately, off of the previous version of the law that was put up before I was even on the legislature, which mimicked the Coiman's law. And this one doesn't at all. And I know, having worked on this bill with some of our attorneys too, we have looked at that particular case that you're concerned about, Patrice. They've looked at it very carefully and repeatedly. So that review has been done, and it doesn't even apply to this one either. So I know they said it, but I just want to make sure I reiterate that particular point, that he's just unfortunately operating off of the view of the old bill, not the new bill. And I would also add just about the bill, our intent on this, of course, was not to shut down any businesses that are already doing some of this work. It was to prevent new waste facilities and any new materials from being burned. That's really the gist of the bill. We weren't trying to put out of businesses that already exist and were doing this. That's where Bill was talking about some of the exemptions. Thank you.
All right, Paul?
Thank you, Bill. I appreciate it. There are actually three parts of Mr. McHugh's letter. There is his letter. Then there is a letter from Lafarge, which takes issue with many of the items of testimony that we heard from environmental advocates yesterday. They cite the city of Baltimore case, which was decided in March. And they say, and I believe that they're probably not kidding, that we intend to vigorously defend our permit and our rights by whatever legal means necessary. So I personally, and I know I'm not a member of this committee, but I am a member of the next one that's going to consider it as a member of the law committee. We have DEC and EPA, which have repeatedly approved their permit to burn TDR, their operational program, which caused them to do a $500 million update to their plant in Queens. Now, they have done more seeker and scientific analysis. I have personally visited them. I've seen their seeker. I've seen the EPA documents that recommend tire-derived fuel as a preferred use for cement kilns. They have done their due diligence, and I don't believe that we as a county should be substituting our judgment for federal and state regulatory agencies, which are I think the Title V permitting agencies. And that's exactly what the Baltimore court has ordered. In addition, I have yet to see an independent seeker analysis on this law, which, as far as I'm concerned, is a fatal defect. We have done seeker analysis for our anaerobic digester. We have done seeker analysis even when we did a lease to Soldier On at the Ann Lee site. We have brought in outside consultants. We have spent hundreds of thousands of dollars to do the independent scientific analysis that shows what the options are and what the benefits are. Now, I went down to this plant and it was demonstrated to me that they are operating under an emissions cap. Their permit says that they were issued, and it was issued, during the Obama administration. And they can show that by using tire-derived fuel, they will not have to use dirtier coal, and there will actually be less emissions. They have the science that backs that up. So for us to substitute our judgment for a full seeker that has been endorsed by DEC and EPA, I find this really isn't the sort of business that we should be in. I recognize the emotion, I recognize the advocacy, and I recognize the feelings of people who should be. But some jobs are ours and some jobs are not. And for those reasons, I won't be supporting this either in the next committee or on the floor. I think what we're asking for, without a full-blown, not the short form seeker, but bringing in some sort of an environmental consultant at the county's expense to do a full analysis, you are inviting a lawsuit. And once again, this isn't an Article 78 proceeding. The lawsuit was issued in federal court, where you can be assessed legal fees for your opponent. So I think your lack, not your lack, Bill, the county's lack, the proponent's lack of having a full-blown seeker, such an important thing to unravel EPA and DEC permits is misguided and without scientific merit. There are lots of people who said, oh, this is going to increase emissions. Well, according to the documents given to EPA and DEC, it does not. I also will point out that the other issue of concern was Norlite. And in the instance of Norlite, the process worked. People raised issues, DEC went in, DEC investigated, and DEC stopped the action that people found objectionable. So for those reasons, I think going forward at this time without doing a legal analysis and a seeker is a tremendous mistake.
Well, I do want to say a few things first, and then I'll call on Matt again. I think he
Well,
has. his hand up.
just one point of order on that, Mr. Reiner. I don't think you saw it, but after Ms. Plotsky made her motion, I did second it. I don't think you saw that in the
Oh, okay.
in the
All right.
screen.
So noted. So noted. Paul, I think that the points you make are all points that we have been deliberating for the last, I'd say, about 5 months. And the reality is that a lot of the statements about science that are made are contestable, have been contested. I've seen other evidence that shows some very different emissions coming out, not the same emissions as coal emissions. In other words, not what the coal releases, but what the tires release in the case of Lafarge, that are of great concern. The synergy between the toxins and the other materials, the particulates and things that are coming out just with coal are of concern to a lot of scientists. And it's not necessarily reflected in, in what Lafarge is trying to do or what they are claiming. The other point I'll make is many of us have seen the hierarchy of what you do with tires. And at the very bottom of that hierarchy is burning them. The only thing below that is leaving them or putting them in landfills, and that's against the law here in New York. So what we're really talking about in terms of do we burn tires is that is the least attractive of all the allowable uses under DEC's hierarchy of best uses. And advocates have been saying for a long time now, hey, we gotta encourage other better alternatives than burning those tires. And in a sense, that what this bill is trying to do in the broader sense is to say all of this waste that we're going to be dealing with as a society, and many of us are aware of, how global markets for waste have changed, is we have to really focus on the recycling and the reuse and all of those other better, higher ranked options than burning. And so in that sense, yes, we're aware of those comments that have been made about Lafarge and DEC and all. We're addressing those in the language of the bill as it's evolved. But those are all, thank you for your comments, but it's not really news.
Well, the lack of a seeker is news.
Well, we have a seeker. Laura is here. Laura, I'll call on you next, but she has done one. And then very recently with some of the most recent changes, she has looked at that again. So Laura, would you like to comment on that? Laura, is you?
Sure, yeah, I'm here. Yeah, well, I, as you know, reviewed it as an unlisted action in that it's a local law prohibiting the burning of waste, certain types of waste. We weren't looking at the environmental impact of burning different waste. It wasn't, the same as, say, conducting seeker on constructing a burning facility. So, and I believe it states in the seeker that, it was based on the provisions of the local law and did not consider the overall waste disposal landscape, on a regional scale. And did not look at burning one thing over the other. It also was not just looking at the issue of tires and Queens. It was just looking at the provisions of the local law to prohibit the burning of specific materials.
Mr. Chairman, point of order.
Yeah.
No one has seen the seeker. It has not been circulated. And with all due respect to Laura, Laura is a fine land use planner. But this cries out for a type 1 seeker. And for a type 1 seeker, or for any seeker, there should be an action to adopt the seeker. And part of the requirement is that the chairman of the legislature has to sign off on the adequacy of the seeker. So I think for the life of me, I cannot imagine that you can undertake a law which would override DEC and EPA on the base of an unlisted seeker and have our chairman sign off that that was an adequate environmental review. I just need to put that on the record. You will do what you will do, and ultimately the county will be sued, and it will cost us a tremendous amount of money because we're not going down the proper procedural path.
Mr. Chairman,
Right.
Frank Canisso.
Yeah, Frank, go ahead.
Could we possibly get an opinion from the county attorney before we move forward with this?
You mean our minority counsel or Patrick? Or, I mean,
No.
Rebecca or Patrick, or is that what you mean? Frank?
Rebecca, Patrick, it needs to be looked at close by some legal beavers to see that we're going down the right road here.
Well, I don't want to speak for them. I'll let them think about it for a moment, but I will say that they've been aware of and on top of the whole process all along. They've seen the secra that Laura prepared before. They've seen in fact, they initiated the recent email chain about, okay, how about this version of the bill? So I know they've seen all that. Rebecca, do you want to comment, or Patrick, either one of you at this point?
Sure. I've only been involved, of course, for the past month, but with regard to that, we have gone over extensively what the law constitutes, what it covers, equal protection issues related to takings, all of that. We have also reviewed the seeker with regard to Mr. Burdorf. This, I don't believe, can be a type 1, and Laura, please correct me if I'm wrong, but only certain specifically enumerated actions are type 1 under seeker. Beyond that, we feel that we have carefully crafted this language to avoid any of the issues that befell the parties in the Baltimore case. And so we don't think that will be an issue moving forward. Brandon, if you want to comment further, or Patrick, certainly you can.
I agree with Rebecca.
I also do.
Can I say
Okay.
something? It's Jennifer Whalen. Hi.
Sure, go ahead.
When
Jennifer.
I hear that a business made $500 million plus, spent $500 million in Reliance to adjust things at its plant so it could conduct business. I think that if we are dragged into court, the county has been suffering. We don't have a lot of money anymore in sales tax revenues and the like. And I just hear like $500 million and federal lawsuits, punitive damages. And I just think that we should really make sure that we're on solid legal ground here before we think of enacting something like this without a proper seeker. And
Yeah.
it seems like there's been a lot of, talk about whether or not the process has been technically even correct. But I certainly wouldn't want to see this county, it's my job to make sure, and our job as county legislators to make sure that the county is shielded from liability. It's the taxpayers' money that we're talking about here. And, you know, I think we're overreaching, but I think that I hear $500 million in lawsuits and seekers that haven't been appropriately or maybe inappropriately not published. I just start thinking punitive damages, and that in and of itself frightens me for the taxpayers and residents of this county. You
Right.
know, this is their money. This
Well,
is not, it's a lot of money.
Yeah. I'm gonna trust our lawyers at this point.
Mr. Chair?
I do want to add that that $500 million number represents a whole lot of different types of investments at Lafarge. And I'm sorry we keep talking about Lafarge because that's not really the focus of this bill, but Lafarge was investing for a lot of different things with that 500 million. Some of them were to try to come into compliance with environmental problems. Some of them were perhaps expansion. Some of it, you know, there are a lot of different things. They were not investing that kind of money for a single purpose. And I do want to just make this point. Lafarge is a cement plant. Cement plants don't feed global markets. They feed local markets. I do not really believe that they're going to close. I'm not concerned about that because I know how cement plants operate in regional markets. It's a very heavy material. It's a low priced material. These kinds of commodities don't get shipped all over the world. Just doesn't make economic sense. They are generally providing local markets, and the markets locally will determine how any cement plant thrives or doesn't. But listen, we are getting low on time here. Matt, did you have your hand up again?
Yeah, I did. And you've actually touched on most of the issues, Bill, which I appreciate. I would add that, you know, what Lafarge did at that, and this bill is much bigger than Lafarge, as you said, but what Lafarge did in their what do you call it? Their revitalization, their you know, changing the stacks was under a consent order from DEC because of previous pollution and nothing to do with what they want to do going forward. But I think our lawyers have done the diligence that we need to, and I'm ready to move the vote. But I do believe Mr. Fine, who's on the committee, was also raising his hand.
Mr. Chair?
So I yield to him.
Mr. Chair,
Chair.
Hold on, wait, did Sam, you want to go? Where did Sam go?
I'm
don't
right
see
here.
Sam.
He's there.
Oh, there you are. Go ahead, Sam.
Thank you, Mr. Chairman. Yeah, I just want to say, I think that our lawyers have looked extensively at this bill. It's been in committee for a while. We've discussed it for a while, and our lawyers have put in a lot of effort to make sure that it's legally sound. And I think it's time to move it forward. I would like to make a motion for a positive recommendation.
Actually,
Mr. Chair,
We have one in a second.
we did have that motion on the floor.
Mr. Chair, can I speak? I am from this district.
Wait, who's talking?
Member, Mr.
George
Chairman,
Langdon.
I'm hearing a lot of different voices.
Mr. Chairman,
Yes,
Mr. Langdon has had his hand up from the beginning asking to speak.
all
So
right.
it's after we recognize him, please.
Okay, George, try to be brief. We're running out of time. And then Bill, did you want to speak also? Did Bill Ricard speak up?
I can say something after Mr. Langdon speaks because he has had his hand up.
Yeah, okay, so George, you first and then Bill.
Listen, I'd like to take, are you hearing me?
Yeah,
Okay. Where I sit right now, I can see that stack. Okay, I'm very heavily interested in this region, in this town. A primary reason I am a legislator today is because of this law, quite honestly. Okay, the residents in this district do not want this law. They didn't want it in Queens, and that's why they removed the old administration. And there was a lot of misnomers that were stated last night. One of them being that we were put in office by these special interests. I would challenge every one of you to go to the State Board of Elections, to the finance record, and you will see that Lafarge or Carver, neither one of the major industries in our town gave one dime to our campaign. We wouldn't take their money. So consequently, the idea that this is supposed to be something that everybody wants, we need to rethink. There's one part that I would like to take. It's a small excerpt from the document that Mr. McHugh sent.
And it is basically an excerpt of what the judge stated. This idea that this is our law is different than the town of Queens is not right. You guys really need to relook at this. The excerpt here, this is the judge's statements. Sulfur dioxides, nitrogen oxides, and mercury among air pollutants, other air pollutants extensively regulated by the Federal Clean Air Act and by extension individual states. Emission standards for these pollutants are set by the EPA after a lengthy public rulemaking process and enforced through the intricate permitting systems administered by the states. Allowing a locality to undermine this regulatory stream by substituting its judgment in place of the decisions by the federal and state government is not consistent with the goals of the CAA and its corresponding statutes. That is why the Baltimore law got struck down, because they were trying to supersede permits that were already issued. And when you look at the cement plant, this says, yes, okay, new things. But the reality is their permits are in place already. They already have their Title V permits.
George, we understand that. We understand that. I just want to say that sometimes when you read the position on one side, it looks very clear, but then you have to understand that there are other documents that make that document less clear. And this is one of those cases where there is other case law that seems to be, that we've seen, that really questions some of those conclusions that you were just reading. So what I want to do now is I want to ask Bill to speak very quickly, and then I think we need to call the vote.
One more comment I'd like to make here. I am very heavily invested down here. Okay, but when you turn around and you want to push this out to a vote, when we have some serious potential litigation issues that is likely going to cost this county hundreds of thousands of dollars, especially given the circumstances, why the rush? They're not burning tires right now. Passing this law is not going to do the homework.
George, I have to say, I don't feel like this has been rushed. I feel like I have been spending half my year in the legislature on this. Our lawyers are going to look at all that. They have looked at all that. So we're moving forward with I would say, due diligence and good respect for all the different views that have been expressed. Bill, can you speak?
I would just
Thank you, Mr. Chairman. I appreciate you giving me the opportunity to speak before your committee this evening. The thoughts of my constituents are always the utmost importance when I decide, how to vote on a measure that's before our legislative body. With that said, I'm going to reserve my final decision until local law B, if it gets to the floor on August 10th. With that said, I too, had several legal questions, as many of you are aware, but I believe at the present time, those legal questions have been successfully answered in my mind. And I look forward to this local law being on the floor on August 10th. Thank you.
Thank you, Bill. All right, I'd like to call the vote now.
I put a motion.
If I may, members of the committee, I noticed that many of you are on mute. If you could please take a moment and turn your microphones back on for the vote, please.
Did all the committee members hear that?
Mr. Tunney?
Mr. Tunney? Yeah, get unmute. Are we all unmuted? Can we tell?
Peter Tunney, you're still muted.
There we go.
All right, what I want to ask is when you respond, yay or nay, please also raise your hand so we can get a good record of how the votes went. So first, I'd like to say who are in favor, please raise your hand and say aye.
Aye. Aye.
Did you get a count?
Count me in, Bill.
Okay, thank you, Frank. All right. Are we all set, council? Do we get that?
Yes.
All right, and all nay?
Nay.
Nay.
All right, we have 2 nay, and was that 7 ayes?
Yes, sir.
Yep. All right, so the motion passes. Very quickly now, I want to get to the second item, and I can't see it because my computer went bad again. Thank you, Granicus. but it has to do with the rail trail maintenance. And,
Snowmobile trail
or,
maintenance.
I'm sorry, snowmobile trail. Thank you. Thank you, since I don't have anything to read now. No, I'm guessing neither does Patricia. So the issue here is this resolution, it's a repeating resolution. It's not county money. It's pass-through money. I don't think there's really any controversies around it, but does anyone have any comments before we move the resolution forward? All right, do I see a motion to move the resolution forward with a positive recommendation?
I'll move.
Vicky?
Second.
Matt, second. Okay, all in favor?
Aye.
Aye.
Raise your hands. Make sure they get counted. Any opposed? No, okay, moved unanimous. I think we're done. Mert, did you just want to say something really quick?
Yeah, I just wanted to say that for the record, a DEC endorsement is not the final oracle. They signed off on the Corning trash burning plant at 79 Sheridan Avenue. And as far as the EPA is concerned, I wouldn't give you a quarter for them over the last 3 years.
All right, thank you, Mert. Okay, is there a motion to adjourn?
Motion to adjourn.
Motion,
Is there a second?
second.
Second, okay, all in favor?
Aye.
Aye, all opposed? All right, see some of you in a few minutes.
Folks, I'm gonna end this one pretty quickly.
What's that?
I'm gonna end